The John Birch Society, JBS, objects to states exercising their power under Article 5 of the United States Constitution to amend the Constitution.
The John Birch Society has been involved for years, the linchpin, if you will, of getting rid of constitutional convention calls in state after state across the country. Because in that we see a very dangerous thing happening due to the precedences of constitutional conventions.
One argument JBS makes against a convention, however, is that the Constitution is not the problem. The problem is that it is not adhered to.
Just remember this. All we need to fix our problems is for politicians to abide by the Constitution the way it is written. All we need to fix our problems is the law, the Constitution, and have it upheld. We do not need new amendments.
This is an argument against amending the Constitution because it is unnecessary. JBS does not oppose amending the Constitution, though. It just opposes the amendment process the framers established for the states to remedy an abuse of power by the federal government.
One of the things that needs to be done relative to balancing a budget and getting back the balance of power within the government and closer to the people is to repeal the 16th and 17th Amendments.
Repealing amendments cannot be accomplished by just adhering to the Constitution. It requires amendment of the Constitution. By its support for these changes to restore the framers' balance of power as originally designed, JBS undermines its own argument against a convention of states.
If people are ignoring the Constitution now, the law of the land, what makes anyone believe that if they have a new Constitution or new amendments to solve problems, that Congress, the President, the Supreme Court, the Army, etc., will listen to these new things?
If JBS truly believes amending the Constitution is such a futile exercise, then its support of amendments, even through Congress, is simply nonsensical. Not only has JBS supported amendment of the Constitution, it has also supported a convention of states in the past. In the 1970s, past JBS presidents encouraged states to pass applications for a convention of states for the purpose of adopting the Liberty Amendment. Today, some JBS leaders and supporters either deny that JBS ever supported a convention of states or claim that the effort was simply a ploy to compel Congress to pass the Liberty Amendment. Regardless of the motives, the fact remains that JBS extolled the virtues of an Article 5 Convention of States in the past in contradiction to its opposition to amending conventions under Article 5 today for any purpose. These actions show JBS is untrustworthy. If the efforts in support of a convention of states for the Liberty Amendment were intended to fail, then JBS intentionally misled its supporters. If the efforts were not intended to fail, then JBS's rationale for them today is dishonest. Either way, JBS has a practice of using words and arguments as means to an end without regard to their truthfulness. The arguments today are no different. Consider two contradictory attacks which JBS makes regularly. First, JBS refers to an amending convention under Article 5 as a constitutional convention, although Article 5 specifically refers to conventions of states. For the purpose of amending the Constitution, JBS ignores the language of Article 5 and the framers' stated rationale for it. JBS erroneously equates an Article 5 convention with the 1787 convention from which the Constitution originated. Obviously, the 1787 convention was not an Article 5 convention of states. Second, JBS argues that if a convention of states is called, that there would be no limits to it. The result, they say, could be a runaway convention which theoretically repeals the Bill of Rights and changes the requirements for ratification. These two arguments, however, are mutually exclusive. If an Article 5 Convention of States necessarily is a constitutional convention, as JBS portrays it, and has power and authority to rewrite the Constitution, then such actions would not be the result of a runaway convention. If an Article 5 Convention of States does not have the power and authority of a constitutional convention, and rewriting the Constitution would exceed its constitutional purpose, a Convention of States, as intended, cannot honestly be called a constitutional convention. JBS does not make these arguments in the alternative, but simultaneously. In any case, we know the framers did not consider an amending convention under Article 5 as a constitutional convention like the one in which they were participating. Close to the end of the Constitutional Convention in Philadelphia, Edmund Randolph and George Mason proposed that a second plenary convention be held after the people had an opportunity to consider the new Constitution to make revisions to it. This was rejected. There was no discussion about Article 5 being such a plenary convention. Therefore, the suggestion that an amended convention under Article 5 is the same as a plenary convention like the 1787 Constitutional Convention is inconsistent with the framers' intent. Similarly, JBS argues simultaneously that a convention of states, once convened, is uncontrollable and that it would be controlled by Congress, not the states. The first argument suggests that any limits placed by the states on the scope of the convention and the duties of the delegates are nugatory. The claim is that an Article 5 convention as a separate political institution would not be subject to control by any other political institution. This is consistent with the runaway argument and is designed to elicit fear of great risk, making the cost of this approach too great. On the other hand, JBS claims Congress can and would determine who would attend and how votes would be allocated among state delegates. This argument is designed to discount the value a convention has for addressing abuses of power by the federal government, making the benefits of this approach too insignificant. Again, JBS does not make these arguments in the alternative, but rather simultaneously. Factually, however, a convention of states cannot be claimed to be both uncontrollable and constrained by Congress at the same time.
We also see it's given power to call a convention. The power to call a convention for proposing amendments is one of those all other powers. Therefore, pursuant to that power, Congress may enact whatever law which shall be necessary and proper for carrying into execution the power to call a convention.
Colonel George Mason strongly objected to Congress controlling the power to amend the Constitution. His objection was ultimately followed by a vote by the delegates to change Article 5 to what it is today. Any suggestion that Congress can control a convention of states represents an intentional distortion of the framers' intent. The objections propounded by JBS are shared by liberal progressive organizations to defeat attempts to remedy federal excesses through a convention of states. For example, when the Montana legislature considered an application for a convention limited to proposing a balanced budget amendment, a leftist group specifically urged Democrat legislators to oppose it. The organization's talking points mirrored JBS's arguments against it. This email message shows how contradictory arguments were presented simultaneously, and JBS supporters were used intentionally to communicate them to influence Republican legislators. Arthur Thompson says that states and legislators cannot be trusted until Americans know the Constitution and insist on it being followed by politicians we elect. What he and JBS failed to recognize, however, is that we Americans who now advocate a convention of states to correct a growing imbalance of power are doing just that. We respect the Constitution as originally intended and we want it back. Meanwhile, the massive debt of the federal government continues to grow with no end in sight. Federal agencies have contemplated banning sales of certain ammunition, indirectly threatened lawful firearm dealers by Operation Choke Point. Agencies purposefully ignore immigration restrictions. They tax individuals for failure to purchase medical insurance with terms mandated by government, and they target individuals based on their political affiliations. Intentionally or not, JBS is effectively working to maintain an imbalance of power which can only grow worse if left unchecked. It is time to hold JBS and anyone else who accepts its arguments in defiance of reason and logic accountable.